Welcome, everyone. My name is Andrew. I'm the founder and owner of Ibis Prep. And today we are doing the first lecture for Torts for the February 2026 MBE bar exam. And we're going to start out with a little bit of fun. We have a guest in the class, one of my SAT instructors, and she's going to be a lawyer one day. So this will be a great introduction. Um, all right, let's see if we can play this Jeopardy game. And if you played it yesterday and the questions are similar, try to take a little bit of a back seat to someone new who can play. And we'll go through it quickly. Don't worry. All right. Unlawful confinement of another. What do we call this? You can write in the chat if you want.
False
Unlawful
imprisonment?
confinement of another. Yeah, false imprisonment, right? Nice job. Okay, a peeping Tom. So if you procure private information from another, I don't know if that word is politically correct anymore. I feel bad for Tom. Class action suit by Thomas's. Um, yeah, it's going to be intrusion upon seclusion, right? That's going to be the invasion of privacy tort. Intrusion upon seclusion is one. There's false light. There's appropriation or misappropriation, using someone else's likeness for commercial gain. And then there's a public disclosure of private fact, but of private information. But the main privacy tort is going to be intrusion upon seclusion. All right, an offensive touching of another, like what Will Smith did to Chris Rock on the stage. Yeah, battery, right? That's like classic intentional tort. For all these torts so far, false imprisonment, battery, you need to prove the intent element, right? It's not just a deviation from the standard of care, it's actual intent. Uh, Extreme and outrageous conduct that causes mental anguish. What cause of action would this be?
Emotional distress?
Yeah, IIED, intentional infliction of emotional stress. Like if you were to paint racial epithets on someone's house, right? To really do something outrageous and cause distress. Okay, the civil equivalent of a criminal theft charge. So if you totally are responsible for the value of, yeah, conversion, right? Different than trespass of shadows, because trespass of shadows is just a a deduction in the total price. But if you are liable for conversion, if the question asks you how much would they be liable for conversion, it's going to be the market value of the good or the shadow or the thing, right? What it was worth at the time it was converted. Okay, so here with negligence, the but-for cause. The but-for cause. It's one of the two types of causation, right? Actual causation. So there's a question about like a kid, calls his teacher ugly or something, and then a year later the teacher commits suicide, and the teacher wants to collect for some claim of action, but the answer is it's not going to be viable because it wasn't the actual causation. What actually caused her to commit suicide was something different. Or like if you weren't feeding your kid, right? So you were neglecting to feed your child, but then the child died of cancer. Well, it wasn't the actual cause for a wrongful death claim. It has to actually be the causation. Um, okay, this one must be the protected class in the design injury to succeed in this claim. It's a type of negligence where the standard of care is defined by a statute. Yeah, it's called negligence per se. So what this is testing is the concept that like if a statute defines a standard of care, like let's say it's a speeding limit and you go above the speeding limit and cause an accident, well, they can sue you for negligence per se. It's assumed that you breached the duty based on the facts at hand, right? But it has to be the designed injury in the protected class to recover for the claim. Like in a car accident, yeah, that's who's contemplated by a speeding limit ordinance. But let's say it's I give this example all the time, but let's say it's a car that's parked outside of a fire hydrant, and then another car comes and sideswipes that car, and then tries to sue them for negligence per se because they violated the statute and parked next to the fire hydrant. They're not going to be able to collect there because the purpose of the statute was to protect people who were, in a fire, right? So that the firefighters could get to the hose and they could spray the fire, whatever it may be. That's the type of injury we're protecting, not just a side swipe on the road. So it has to be like who was protected and who was contemplated to seek refuge in the statute. So that's negligence per se. Okay, so this will cut off liability. It's either intervening or superseding. One of them cuts off liability, which would lead to indemnity, and then the other allows for contribution, right? This is superseding. Superseding will totally cut off liability. I'm telling you all on the MBE, be very wary to choose that it was a superseding event that cut off liability. It's more likely that it was a foreseeable consequence of the original tort. So the original tortfeasor could be liable for the total extent of the injury. Like the classic example is a car driver causes an accident and the person breaks their leg, right? The driver's liable for the leg injury. Now, let's say that person is in crutches and they're at the grocery store and they slip on the banana peel that was left on the floor. Well, was them leaving a banana peel a superseding event? No, it's definitely foreseeable that a person who injures their leg could be in crutches, and then when they're in crutches, they slip on a banana peel, so they could be liable for the arm injury as well, right? Like I said, there's a question about like a ladder is left open next to a window, and then a thief climbs up the ladder and steals the jewelry. Can the worker who left the ladder be liable for the loss of jewelry? Potentially, under that theory that it was foreseeable to invite crime by leaving a ladder next to a window or things of that nature. So be very wary to say that this event totally cuts off liability. It could happen, right? Like if someone, takes out their gun and starts shooting people and it had nothing to do with you cutting the guy off in traffic, right? Like then maybe that would be an intervene or a supervening uh, cause. But on the MBE, usually the thought is like it's a domino effect and it's all foreseeable that one domino could lead to the rest. So just some thoughts. Okay, so you take the plaintiff as you find them. What do we call this? It's like the first thing I learned in law school, I remember. Yeah, the eggshell plaintiff rule, which means that like if you punch someone on the arm because you're just being a jerk and you punch them in the arm and they just had shoulder surgery and now just because of your small little punch, they have to get $100,000 worth of medical expenses, you're going to be liable for the totality of those expenses. You take the plaintiff as you find them. So you have to be found liable, but once you're found liable, you're liable for the totality of the damages, regardless if they're a quote unquote eggshell plaintiff. Um, okay, so the thing speaks for itself. It's a little bit of Latin. Yeah, res ipsa loquitur. The thing speaks for itself that injury would not have occurred in the absence of negligence, and it's clear from the facts that the person who there was one person or one group of people that were in exclusive control of the injury causing instrumentality. So like the pot that falls off the balcony. Well, pots don't just jump off of balconies. And if we could show that it was definitely your balcony, then you are liable. Now, if there's like 20 balconies and we don't know which balcony the pot fell off of, well, then you would have to prove whose balcony it was first. You can't just say, oh, you must have been one of the 20 people. No, you have to prove that they are liable before we can say the thing speaks for itself. Another example is like the doctors who leave a medical instrument inside of someone's body. Like then they do the X-ray and they're like, oh, you have a scalpel in your one of your organs. Well, it's like, okay, the doctors are liable because res ipsa loquitur, the thing speaks for itself. Scalpels don't just jump into people's bodies, and the scalpel is under the exclusive control of the doctors, right? Okay, so the MBE assumes this type of relief for any defendant can be held totally responsible for the entire amount of damages. Um, it does assume joint and several liability, but that's not what this is asking for. Joint and several liability. Um, actually, yeah, wait, I think this is joint and several. Yeah, you're right. This is joint and several liability, where any defendant can be held liable for the total amount of damages, right? So, if sorry about that. So, like, if A, B, and C are in a car accident, right? And it's B's 40% fault and C's 60% fault. Well, then A can sue either B or C for 100% of the damages, and then B or C would have to seek contribution from the other. But the reason is that B and C together are liable for A's injuries, and together they're jointly and severally responsible for making the party whole again. So you assume that if they tell you they've abolished joint and several liability, then A can only recover 40 from B and 60 from C. But if they don't say anything, then you have to assume that A can recover 100% from either liable party. The MBE assumes this type of relief, which means that even if a plaintiff is 99% at fault, they can still recover. So yeah, pure comparative negligence. Exactly. We assume pure comparative fault, which means that, A, B, and C are in an accident, and let's say A is 60% at fault, and then B and C are each 20% at fault. Well, A can still recover 40% from B and C collectively. Or if A was, 10% at fault, B was 80% at fault, and C was 10% at fault. Well, A and C can recover 90% potentially, and B can recover 20% potentially. I'm sorry, A and B can recover 80% or 90% potentially, and B could recover their 20%. The point being is it doesn't matter. If you're any amount at fault, you can still recover. Now, if they tell you that the jurisdiction follows modified or comparative or partial fault, so modified or partial fault, that means if a plaintiff is over 50% at fault, they're barred from recovery. So you assume pure where anyone can recover, even if they're not 90% at fault. Hey, take care, Bianca. Good luck with your SAT session. But yeah, we assume pure comparative fault where anyone can recover, even if they're 90% at fault, 98% at fault, 60% at fault, whatever. If the facts tell you that this jurisdiction is modified or also known as partial, those are synonyms, modified and partial, that means if a plaintiff is over 50% at fault, they cannot recover. So if they're 51% at fault, 62%, 80%, they cannot recover because they're over 50% at fault. If they're 40% at fault, then they could recover the remaining 60%. Now, if they tell you that the jurisdiction is a contributory negligence jurisdiction, contributory fault, or they'll say traditional, comparative fault or common law comparative fault, like if they tell you it's common, traditional, or contributory, that's the key word, contributory negligence, that means that any amount of fault is a bar to liability. So if someone is 2% at fault, they cannot recover. The classic way of testing that is if they assume the risk. Assumption of risk is a complete bar to recovery in a contributory negligence jurisdiction. Yeah, Morgan's asking about Florida, right? This is the MBE, so you want to assume like, we're assuming pure. We're going to read the facts to let us know if we should apply modified or partial or contributory if the facts say so. And then, yeah, Morgan's right. The state of Florida, they've recently moved to modified or partial, which means over 50% of fault they cannot recover. I know we have another guest in the room. What's up, Alex? How are you?
Hi, good. How are you?
I'm amazing. How is life as an attorney? It seems like a lot of traffic.
Busy.
Yeah, that's what happens. Be careful what you wish for, ladies and gentlemen. You might just get it. Alex is a full-time attorney now, but she promised me as a student that she was going to stay on and help others. And now she's doing it and loving it. So, real quick, Alex, just because the recording's already started, you have a few students in the room. I know Ngozi and some others that you are their ambassador. And, you're fresh off of passing the MBE hard ass test. I don't sugarcoat it. What advice do you have for students to pass the MBE in February?
Um, I did thousands and thousands of questions. Like I finished the U World Q Bank, I restarted it, I finished Birdie, I did it again. Like you just have to keep repeating the questions, and I think that that's the biggest thing that makes a difference because you start to recognize the patterns in the way that they word the question. So I think look for the patterns, and you really understand then like when they're asking this question, they're leading you towards this type of answer. And when I took the MBE, I actually understood the pattern so well. I recognized a question from the test that I had taken, like one of the practice exams that I had taken. It was the exact same question, just
You
the facts were changed like a little bit. So
Right. You felt like that. I feel like that too, that I mean, trust me, there are some questions you're like, I have never seen this before. Like, where did they even come up with this? That'll happen. But there are a good amount of questions where you're like, all right, I'm very confident in this one because I have experience with a very similar fact pattern, right? Like, I think that's like something that everyone can agree on. And, Alex is amazing and she passed the MBE. And I wish she had some like secret special, but there really isn't, right? It's repetition of doing the practice questions and just getting to a higher point of mastery. And Alex has done that and now she's on the other side. And she's just a good example of like hard work pays off. She was always, coming to class, doing her work, doing practice questions, never satisfied. And then, she showed up ready to go. Also, I told the class about you because the Steelers played last night, and you guys look pretty
Oh,
good finally.
we
Yeah.
did. First time in a while, actually, kind of. So yeah. I run Birdie. So I have an email. It's alex@ibisprep.com. If you ever have any questions that you're not sure of or you want to argue about, I don't know if I'll argue with you, but you can always reach out and I'll be happy to talk about it or pass it on to Andrew if I think the question needs to be reworked. So please don't hesitate to reach out if you ever need anything. And also, if you ever want to talk about law, I'm happy to as well. I do high net worth law, so M&A, but for a lot of times for individuals worth over 50 million. So it's really interesting work, and I'm always happy to talk about it if anyone wants to learn
Damn, I'm
more.
just under the cut. No, I'm just kidding. But that sounds amazing, Alex. You're amazing, and we're super happy for you. And yeah, she was instrumental in a lot of the work we've done on Birdie because there was a space out there for differently phrased questions and some, more questions and just different things. Because like she said, she did UWorld twice already. Like she had gone through all the NCB questions a couple times, and it was helpful to see, new questions, new concepts, and just different angles of things. So she's doing everything purely from her heart. You can tell she's a big shot attorney now, but she really cares about this process because, it opened up a lot of doors for her and she wants to reach back and help open up these doors for everyone here. So really great, Alex. You gotta stick around and see if you can answer his next question though. It's just you. You're the
Oh
only one. Yeah, I
gosh.
gotta see. I gotta see. It can't be that hard.
Andrew,
It
I
can't
don't
be.
think I remember anything, but
It can't be that hard. All right. Um, Here we go. This type of relief is to punish and usually limited to 3 or 4 times compensatory or $500,000. Not
punitive?
compensatory. Punitive damages, exactly. Alex, you're doing amazing. You remember everything. You could probably pass the test tomorrow. But yeah, thank you for coming. Does anyone have any questions for Alex at all while we got her? Miss $50 million or more? Anyone here have a moment of her time? Or no, she's awesome. That's really great. And I'm like so happy for her. It makes me happy to see people succeeding. And this test is hard. I always tell people it's hard, but she listened and followed through, and now the whole world is at her feet. Speaking
No,
of feet, I know
Andrew's the best. So
I didn't even
seriously.
mention that. Yeah. Yeah, you're amazing too, Alex. And she does have a surgery coming up, so we wish her well
Oh
on her
my
surgery.
God.
She's a super athlete. So yeah, thank you, Alex. All right, let's continue on. And I put her email in the chat, and you can message her about any of the birdie questions or ever, or if you just want to talk about, strategies for success, she's definitely here for you. And she's gonna be helping Danny do the accountability partner. So make sure you fill out that sheet because she's someone who benefited from the program and the boot camp, and Alex did it all, and yeah, we're super happy to have you here, Alex. So thank you. Have an
Yeah,
amazing
you're
night.
so welcome. Please cut out this part of the recording. Okay. Bye.
Bye. Go Steelers. All right. So vicarious liability in an employer-employee relationship, what do we call that? It's a little bit of Latin for you. uh Yeah, responding superior, right? You're looking for a master-servant relationship. Like there's a boss who has his kid, or not his kid, his employee go out and do something, and the employee causes injury. The boss can be found liable under that theory of vicarious liability, responding superior. It's a master-servant relationship. Look for non-delegable duties, like the mall has a non-delegable duty to maintain a safe premises. So if the cleaning company doesn't clean and someone slips and falls, well, the mall can still be held liable under that theory of master servant, principal agent, and such. Also recognize the difference between a detour and a frolic. Like what we just did with Alex was a detour. It's getting kind of frolicky, but it was a detour, right? It was still within the scope of business. But then, if we start talking about the Steelers for like 2 days, right, that would be a definite frolic. So employers are liable for negligent acts that occur during detours, but they're not going to be liable for negligence that occurs during a frolic, something super outside the scope of business because of just the nature of the event. All right. The mall, for instance, has this type of duty when it comes to cleaning the floor. Kind of gave that out more quickly. Yeah, non-delegable duty. I just mentioned that. Okay, when someone is allowed to detain someone for a reasonable amount of time to investigate. Yeah, this is a shopkeeper's privilege. Now, this is for false imprisonment, but remember, okay, so the security guard thinks that Susie stole the goods, right? The security guard thinks that Susie stole the purse. Hey, Susie, come here. I gotta check if you stole the purse. And Susie's like, no, this is my purse. Like my grandma sewed this 30 years ago. Like, I don't know what you're talking about. At that point, the security guard has to let Susie go. If the security guard continues to detain Susie, then it can become false imprisonment due to the circumstances, right? They've extended their privilege. You can use your neighbor's dock for your boat in a storm, for example. This is another privilege. Yeah, necessity. This one comes up a lot. Like you have the privilege of necessity because you know you need to land the plane, emergency landing in someone's farm. Well, shit, the plane was going to crash otherwise, or the car is going to get caught in a snowstorm, so you had to put on someone's driveway, something like that. So when someone allows another to commit a tort upon them. Yeah, consent. I always think of boxing for consent, right? Like if it wasn't for that, you are allowing someone to punch you in a fight, right? Like you can't get in a boxing match and then sue the person for battery because you've consented by the terms of the engagement. All right, when a bomb inspector performs his job, for example, if the bomb were to explode, what would we say the bomb inspector has done here? If the bomb were to explode, that you could argue that he's not going to be able, yeah, he's assumed the risk, right? Like that's your job. That's the assumption of the risk of your job. So assumption of risk is that there's another question on the MBE. You'll see it's like grandpa goes to kid's house and kids always have toys on the floor. Grandpa knows this. Then one day grandpa goes over and slips on the toys. Well, grandpa cannot recover because he assumed the risk. He knew that there were toys on the floor, whatever it may be. And remember, assumption of risk is a complete bar to recovery in a contributory negligence jurisdiction, not in a modified or a pure, but if it says it's traditional common law contributory negligence, then assumption of risk would be a complete bar to recovery. You can claim for yourself or for property or for others, and it must be reasonable. So it's a privilege, like, yeah, defense, self-defense, defense of others, defense of property, right? You can stand in the shoes and defend people, and typically you can meet force with force, right? Like that's, you can arise to the occasion. This must be proven if claiming defamation of a public figure. Yeah, actual malice. My neighbor saw me getting this Coke before class and he was just like shaking his head because I used to be such a health nut. Now I'm like dad bod. All right, so I don't know. Let's table that. We'll see what I decide next week. New Year's, new me. So yeah, actual malice. You need actual malice because it's a public figure, a matter of public concern. There's one question on the MBU that can be troublesome. It's like this guy is the general manager of a restaurant in town. Well, he's still a private figure. It's not enough to become a public figure. You would really have to like be pretty famous to be a public figure. I don't know how famous, but famous enough. Damn, you heard Alex say $50 million clients? I need to get on that level, right? Wild animals, abnormally dangerous activities, and products liability are subject to this. Yeah, strict liability. Strict liability, it means that you don't really need to show causation. Like if they were injured by the product, then you're going to be liable, right? So products liability, it means that a supplier, retailer, producer, manufacturer, distributor placed a defective product in the stream of commerce. Anyone downstream of the defect can be held liable. So, if this Coke had, a piece of glass in it, well, whoever produced it can be held liable. Whoever was the retailer and distributor that sold it to the store can be held liable, and the store can be held liable if it was all the way upstream. Now, the person who created the cap, right, say this was separate and they just sent that, they're a component manufacturer and they did not have a defective product leave their hands. So they cannot be held liable, right? Another way they test that on the MBE, I just remembered, is like it can't be a user of the product that you sue. Like if the dentist is doing dental work and he breaks someone's tooth, you can't because the dental tool malfunctioned, you can't sue the dentist for products liability, strict liability, because the dentist is a user of the tool, right? You would have to sue the producer of the tool, not the dentist who uses the tool. So that's a little bit tricky. Another thing is that, there's the uh economic loss doctrine, where if it's just pure economic loss, that's not a products liability case. For example, the NCB question that I've seen is like there's an RV that someone has, and the RV explodes and blows up, but it doesn't cause any injury to any surrounding property or to any people. That's not a products liability claim, right? That's a refund. That's a contracts claim. And yeah, Summer, I had to go to the dentist too, right? All this Coca-Cola goes straight to my teeth. Um, I don't know. You guys just caught me at a weird time in my life. I used to be super, super healthy. I'm gonna get back there. Trust me. But I need a month or two to chill the fuck out. All right. So what is strict liability? Okay. So a broken trampoline, for example, what would we call this? Broken trampoline. Yeah, attractive nuisance. So this means that they've lured a child onto the property, and the child will be treated as a invitee instead of a no, unknown trespasser. I mean, there's a duty to, make safe and warn of dangerous conditions and things like that. That's the attractive nuisance doctrine, where a child is essentially lured onto the property because a reasonable kid would want to play on a broken trampoline. I don't see trampolines like I used to. Growing up, that was a big thing, trampolines. I'm from the trampoline era. Okay, so false or damaging statements concerning crimes of moral turpitude, loathsome diseases, unchastity about a person's business. Yeah, it's defamation would be per se, exactly. Slander per se, or libel per se. Like there's a question where it's like, Tommy calls Susie a thief, right? Well, that's per se, because that's a crime of moral turpitude, right? To be a thief. So things like that. Remember, truth is a defamation, is a complete defense to defamation. If I say Susie's a thief and Susie's got a hella criminal record of thievery, then that's not defamation. That's like saying, uh I don't know. I can't pronounce this guy's name. I was gonna say Victor Wembanyama is tall, but I can't even get his name out of my mouth. How do you say it, Nick? Yeah, I know you know.
Wembenyama.
When Mignana, yeah, it's like saying he's tall. Like that's not a defamatory statement. That dude is pretty tall. Okay. I like that they asked him who's the best player in the league. He said it's gonna be me. I like that. I like that he's got confidence. All right, so the implied warranties in a products liability case. What do we think? And Diego said club earlier, yeah, crimes of moral turpitude, loathsome disease, unchastity, and about a person's business. Those are the times where damages are presumed for defamation. And remember, defamation of a public plaintiff, you need actual malice. This one, the implied warranties in products liability, it's going to be merchantability and fitness for a particular purpose. Merchantability means it works, it functions, and fitness for a particular purpose means that it works and functions for a particular reason it was warranted to, right? Like this is a high speed car tire, and then you go on the Autobahn and the tire explodes. Like, well, it didn't fit the particular purpose, right? Okay. All right, premise liability. So these people are owed the highest duty of care. I think I mentioned it a little bit earlier. Yeah, invitees, right? Invitees technically over licensees are very similar. Invitees, though, are typically business guests, where licensees are social guests. Invitees, they also owe that duty to make reasonable sweeps or inspections of the property. The way they test us on the MBE is fucking ridiculous, but like I told Alex when I told y'all, it's a crazy test. But the way they test us on the MBE is this. There's a banana on the floor, right? It's a pruned banana. Okay, so it's a pruned banana. So you're supposed to know that it's been on the floor for a while. If they say it's an unpruned banana, then you're like, oh, well, it wasn't on the floor that long. They didn't really have a duty to make a sweep. So how pruned the banana is kind of sheds light on how long it's been on the floor. Another way they test this is the block of ice, right? If it's a block of ice, well, it just fell. They didn't have any time to inspect it. If it's a melted puddle of ice, then yeah, they fucked up, right? Like they should have inspected it and things of that nature. So like it's a cheeky little test, and there's a lot of wordplay on it. I like the test for that reason because some of the questions, I swear I won't really know what the answer is, but I'll be like, it's got to be this because they wouldn't have included that language unless they were pointing me to that answer, right? Like, the example I give it will be like, Tommy orally over the phone spoke to Susie. And it's like orally over the phone. Like, why would they make that point? Or like, there was no writing between, like, they sometimes just mention things to like really point you to the correct answer. And it's all about specific words and things like that. I got this new phone. I cannot turn it off from beeping, but okay. I'm gonna throw it across the room. So pretty amazing. All right, we got a lot of things to do today. I feel like, torts is a subject that we should do really, really well on, and I want to make sure I cover everything. I'm gonna go over, I got two PowerPoints, one that Julian made, one that I made. Yeah, go over both of them. Two for the price of one. I was looking for that PowerPoint yesterday, but I guess he did MBE. Julian is one of my instructors too, who is also one of my students. He actually is a pro basketball player in Europe. He's a cool dude. Got some cool people on my staff, Alex and Julian. All right, I just picked people from my former students. So negligence is 50%, intentional torts is 16.7, strict liability, prox liability 16.7, and other torts is 16.7. So yeah, it's mostly negligence, right? It would be very negligent not to study negligence. So assault and battery, assault is putting someone in the reasonable apprehension of an offensive touching. Battery is that offensive touching. Remember that assault, they need to see it coming. And typically words enough are not alone to constitute assault. If you say, hey, I'm going to do something to you, it's got to be coupled with some like, some type of activity that looks like assault. You cannot assault someone who's sleeping, right? Because they can't anticipate it. Battery is a dignity tort. What that means is like they don't actually have to get injured. It just has to be offensive contact, like right, like the Chris Rock Will Smith thing. I don't think Chris Rock really felt that much of an injury, but it was definitely battery because it was an affront to his dignity for sure. These are intentional torts. You're looking for intent. There's one question. It's like, someone blows smoke in someone's face. And again, y'all don't really have that issue anymore because this is 2025. When I was growing up, you go to a restaurant and they would ask you, do you want to sit in smoking or non-smoking? That was like the number one question because the restaurants were split. And it was so ridiculous because it's a fucking restaurant. Like if you're smoking on the left, the smoke will travel to the right. Like there was no non, it was all smoking, but whatever. We used to sit in smoking because we were trying to get our food quickly. But anywho, the question is like, if you blow the smoke in someone's face, which question is not important? And then it was like, did he intend to do it? Does smoke have the properties necessary to constitute like a touching or whatever? And then the correct answer, what's not relevant is, was it reasonable to blow smoke in his face, right? Because reasonableness, when it comes to establishing the tort of an intentional tort, like assault or battery, is not important. Reasonableness is important for negligence, a deviation from the standard of care. But reasonableness does come into play for things like battery when we're talking about self-defense, right? As a defense to battery, was it reasonable to defend yourself in that situation? Objectively reasonable, not subjectively. Like if you thought, he was attacking you, but that was totally unreasonable to think, then self-defense would not be proper. But if someone in your shoes would have felt under attack and it was reasonable to use defense, then self-defense would be proper. So reasonableness is not important when it comes to establishing the intentional tort itself, but you may look at reasonableness when it comes to something like determining whether it was privileged, if you may. So assault and battery, assault is intentional act by defendant, creating plaintiff's reasonable apprehension of harmful or offensive contact to plaintiff's person. An act by the defendant that creates a reasonable apprehension of fear in the plaintiff. So they have to be aware of it. You can't sneak up from someone behind and assault them, right? They have to know about it. Words alone are usually insufficient unless coupled with some conduct. So immediate or harmful offensive contact to the person, the plaintiff must apprehend an immediate or imminent battery. Words or threats of future battery are insufficient, right? Like, I'm going to beat you up tomorrow is not assault. It's like, I'm going to beat you up now, and they raise their fists. Intent and causation. And then battery. So an intentionally harmful or offensive contact to plaintiff's person by defendant. The elements are harmful or offensive contact by defendant under the reasonable person standard. Would a reasonable person think the contact is harmful or offensive, right? So again, it's not reasonable whether they intended to do the throw the punch. It's whether would a reasonable person find it offensive. And like I said, it's a dignity tort. It doesn't have to be like harmful, injurious. It just has to be reasonably offensive to their person. It includes anything connected to them, like their hat. Okay, here's a tough question. So if you strike a horse and someone's sitting on the horse, right? Don Quixote, let's say, are you going to be liable for battery on Don? The answer is yes, because he's on the horse, right? The horse is like part of him. Now, what if Susie is in the car and you strike the car? Is that battery to Susie? The answer is no, because she's confined in the car. The car's like protecting her. So it's kind of tough. There's also this concept of transferred intent, which could be tort to tort, or it could be person to person. So if I walk up to Johnny and I'm like, hey, I'm gonna like throw a punch, but like stop it, like kind of just, boys will be boys, right? So I throw the punch at him just to like, I don't plan to hit him, but you know, I fuck up and I clock him in the nose, even though I intended assault, that will transfer to battery, right? Because the intent can transfer. Fair enough. Now, all right, what if Johnny calls, I've had this beef with Johnny. I go to solve it with my fists and I go to throw a punch at Johnny. Johnny ducks out of the way and I hit Joey, right? Well, I was intending to hit Johnny, miss Johnny, and hit Joey. We can transfer the intent from Johnny to Joey right there, right? So transfer intent could be tort to tort or person to person. Now, what if I'm hunting deer, right? Can't imagine me hunting a deer, but it could happen, I guess. I don't know. I'm like, it just seems boring to me, and like I kind of like deer. I don't want to shoot them. But anyway, let's say I'm hunting deer. So I'm in the woods and I see this great deer, right? It's my biggest fucking opportunity. And I shoot the deer, but I miss, right? I'm not that good at shooting deer, apparently. And I hit Steve, right? Can Steve sue me under a theory of transferred intent? No, because I intended to shoot a deer, not a person, right? It's not going to be like that. It would be person to person or tort to tort. It would be striking a horse, but it wouldn't be striking a car that someone is inside. Okay. So yeah, self-defense and consent, right? Like these are going to be defenses to battery. I said boxing, they consent to being punched. Self-defense, if Johnny comes after me with the punch, I'm allowed to punch him back in self-defense, right? Fair enough. Okay, false imprisonment, an act or failure to act by D resulting in plaintiff's restraint or confinement to a bounded area. So an act or omission resulting in plaintiff's restraint or confinement. It does not have to be physical. Threats of force, failure to release, invalid use of legal authority. Duration is not important. A brief confinement will suffice. And the P is confined to a bounded area. So the plaintiff must be aware or be harmed by the confinement. So if you were in the library, they locked the doors on you and you just sat there and read a book, and then they unlocked the doors and you walked out, and then you found out the next day you were bound, you wouldn't have an actionable, viable case, right? Because you weren't harmed, nor were you aware of the confinement. The freedom of movement must be limited, so locked in a house, room, closet, etc. They must have no reasonable means of escape. So if a reasonable person could get out by like opening an unlocked door, there would be no false imprisonment. And then intent and causation, right? It's got to be intentional. This is an intentional tort. Shopkeeper's privilege. A store may detain a suspected shoplifter at a store property for a reasonable period of time. They have to have reasonable cause. The store must have reasonable cause to believe the detainee stole or attempted to steal store property. And limited duration. They may only detain a suspect for a short period of time and only for a purpose of investigation. The shopkeeper may be held liable for any harm caused by acts exceeding the privilege. So pretty easy with false imprisonment. IIED is the plaintiff acting abominably, right, like the snowman, or outrageously with the intention of causing the defendant to suffer severe emotional distress. It's typically done by defendant vocally issuing a threat of future harm to a plaintiff, right? Like just outrageous behavior that causes emotional distress. If they say like, it's got to be prolonged distress too. If they say Tommy was startled and then went off with his day, right? Or he was annoyed by it, that wouldn't be enough. It has to be like now for, a extended period of time, he's suffering some sort of anguish or distress. IIED claims, they could be tough because it could be like a bystander claim, right? There could be, IIED would be to the person, and then someone who's in the zone of danger can potentially have an NIED bystander claim if they're, have a close relationship to the person and they actually witness it, right? Like there's other claims that could come out as of a IID and NIED, and those questions can be kind of tough. But for IID, you're really looking for outrageous behavior that leads to emotional distress. Trespass to land is a common law tort that occurs when an individual or the object an individual is controlling negligently or intentionally enters onto another's property without the legal right or consent to do so. So trespass is kind of like battery when I said it's a dignity tort. If I walk over my neighbor's lawn and cause no harm, I'm still liable for trespass because I, trespass on their property, right? Or if I build a shed and it's encroaching on my neighbor's yard, right? That's trespass. Even if I didn't intend to do it, I like did it, and what I did was intentional, and that was trespass. Obviously, the privilege is a good defense to trespass. If you're privileged to dock the boat or to land the airplane or whatever it may be, right? Then you'll only be liable for the actual damages if it's a private necessity. Trespass of shadows and conversion. So conversion provides a remedy for deprivation that's sufficiently serious that the tortfeasor is liable for the full value of the property. So if they ask you, you gotta I always read the call to question first because it'll point you to an answer, right? Like if it says, what may Susie receive for an act of conversion, it has to be the full value of what was converted, right? The market value on the day it was converted. So it requires very substantial exercise of control or dominion inconsistent with the plaintiff's rights. There's one question that's a little bit tough. It's like someone borrows the car, drives 200 miles, and causes $2,000 worth of damage. Well, they say conversion, and it's the full price. Because why? The wear and tear of driving 200 miles plus the $2,000 in damage is enough to be substantial exercise or control. For trespass of shadows, there's a question that's like someone leaves their dog outside of a store and then someone's outside petting the dog. Is that trespass to shadows? And the answer is no, because they didn't deprive them of their possession or use of the property, right? So it's like there has to be like you take the bike and you go on a little joyride or something. You spin it around the block. That would be a trespass to shadows, a temporary interference or mere damage, right? Not sufficient deprivation that leads to total liability for the full value of property. That would be conversion. So trespass to land, trespass to shadows, conversion, IED, false imprisonment, assault, battery. Those are some of the main intentional torts. Maybe I'll talk about this on Julian's PowerPoint, but there's also misrepresentation, like intentional misrepresentation. It could be a contract claim as well, but recognize that what's tested for that tort is that there has to be damages, right? Like if you misrepresent something and then they buy it and then resell it for the same price they bought it for, they didn't suffer any damages, so there's no claim of action there, right? So that's a misrepresentation. There's also tortious interference, like intentional interference of a business relationship. That's when a third party has knowledge of a contract between two other parties and they interfere with it, right? Yeah, I was gonna think of an example, but it's not a good example. Okay, so nuisance, right? Nuisance, the interference must be offensive, inconvenient, or annoying to the average person in the community. Illegal activity, noise pollution, light pollution, water pollution, noxious odors, fences, constant barking, all may rise to the level of a private nuisance. Whatever the type of nuisance, it must be unreasonable. That they test a lot, that like the person had heightened sensitivities, so there's no viable claim. Like, if the person is nocturnal and they sleep during the day, right? And then the neighbors are outside playing in the afternoon loudly. Well, you have heightened sensitivity to loud playing in the afternoon because, you're nocturnal, right? So like there's no claim of action there. So look for that answer that there's no claim of action because they have abnormal sensitivities to the nuisance. A private nuisance is brought by a plaintiff, right? Like plaintiff to defendant. A public nuisance is brought by like the attorney general or someone on behalf of the community because it's annoying to the community at large. So defenses to intentional torts are like consent. We talked about allowing the tort to occur, self-defense, defense of another person, necessity, all solid things that we talked about. Okay, so the majority of the MBE when it comes to torts is negligence, duty breach, causation, damages. We talked about this in Jeopardy. The MBE assumes joint and several liability for negligence, which means one defendant can be held responsible for the damage attributed to all the defendants. So if A is injured and B, C, and D are each 33% liable, A can recover 100% from B, C, or D, right? That's what that means. Anyone have any questions with that joint and several liability? Crucial concept to understand. You'll like 100% get a question on joint and several liability. Also on pure comparative negligence. And I know people jump right into the test, but when you open the test on test day, it does say on the very first page, assume joint and several liability and assume pure comparative negligence. Like the only like things they tell you, it's like on the SAT or on the ACT, one of them, they give you like the Pythagorean theorem or something. Like, here you go. It's like one little thing that they tell you, assume joint and several liability and pure comparative negligence. But they could very well tell you in the facts that this jurisdiction has abolished joint and several liability, or this jurisdiction follows traditional rules of, contributory negligence or modified partial comparative fault. They can tell you in the facts, and you got to be able to answer that question properly. So for duty, they'll be held to the duty of an ordinarily prudent person under similarly situated circumstances. I remember when I took the California bar, when you take exams and you go through life, things stick out to you. It's never the ones you get right. It's always the ones you get wrong. It's always the ones that you're stuck on. And that's just like, it's like the iceberg theory or something. I don't know what it is, but there's just a way of thinking that like little things that mean just as much as everything else get stuck in your mind as bigger. So for me, it was this one question. I was cruising through the MBE and then I got stuck on this question. And then afterwards I looked it up and realized I got it wrong. And like, I can never stop thinking about it. But yo, I'll get it right on test day. And honestly, I feel like most students get it right anyway. I'm the idiot who got it wrong, but it is what it is. So the question was, an amateur skier causes an accident. Will he be held to the duty of care of an amateur skier, an ordinarily prudent skier, a snowboarder, or a kayaker? And I was like, shit, is it going to be an amateur skier or a skier? And the answer was a skier. If you're an amateur at something, you don't get a reduced standard of care for not being good at it. You put yourself on the mountain, right? I'm trying to go skiing soon. I want to go to Banff and Lake Louise. I don't know why. I just decided on that. But anyway, the ordinarily prudent skier will be the standard for an amateur skier. You don't get a reduced standard for being an amateur. Now, if you're an expert skier, right, then you will have a heightened standard of care because you can't just disclaim your expertise, right? Remember that medical professionals like doctors are typically held to a national standard of care. Otherwise, it would be more localized. Young people, children are held to the standard of care of a child with similar intelligence and capabilities, right? They put little little clues on the test. It'll be like Susie, a super bright 12-year-old, walks down the park and there's a sign that says warning, the ice is thin. It's like, well, shit, they said she's super bright and she's 12. So like she can read, you know what I mean? Like you got to like kind of make some assumptions based on the fact pattern. So breach is just a deviation from the standard of care. So, like if you fail to do as you were supposed to do, you do not have a duty to rescue, right? You could, walk by, see someone struggling and just keep on moving, right? You're allowed to do that. But once you start rescuing someone, you have a duty to continue to rescue them in a reasonable manner, right? Like, and then here's the other one. Danger invites rescue. So if I'm hanging off the cliff and someone comes to rescue me, well, I'm liable for the injuries they incur for rescuing me only if I was negligent in arriving at that situation, right? Like if I did nothing wrong and now I'm just hanging off the cliff and then they injure me and they rescue me and get injured, I'm not going to be liable. It's whoever caused me to fall would eventually be liable. But like the point is, if you are negligent in creating the dangerous situation, danger invites rescue, and you could be held liable for the rescue. There's also like the firefighter rule and the police officer rule where like a firefighter can't sue someone for getting injured on the job or a police officer on the job because that's part of their job, right? So there's a lot of like little thoughts here. Summer, you have a question?
Yeah, I don't know if it was on Birdie or if it was on UWorld, but recently I had a question similar to about like whether or not there was a duty to aid. And I think it was a woman who was in like a gym And she basically admitted that like she was using the wrong equipment or weights or she wasn't trained and somebody stepped in to help her. And the question, and he ended up getting injured, the guy that stepped in to aid. And the question was like, is the guy able to collect damages? And I said no, because there's no affirmative duty to act or aid. But because the woman was basically, like negligent and wasn't careful, and she admitted to that, he was able to recover. It just made me think of that. And I that just didn't seem like a very natural, like logical conclusion to make, and I got it wrong, so it just stood out to me.
For sure. It didn't seem natural to me either because it's like, well, yeah, danger invites rescue, but why does it matter if they ended up there, they should be liable for the rescue. But yeah, if they were negligent in creating the dangerous situation, then they're going to be liable for anyone who comes to rescue them because of that exact statement, danger invites rescue. Um, yeah, tough test. Okay, and then causation, right? Actual and proximate. Actual, the but for cause, like it was the domino that, caused it, not something that was unrelated, or wasn't the actual causation of it. And then proximate cause, the foreseeable plaintiff, the zone of danger theories. Um, I'm telling you, on the MBE, be very wary to say that it wasn't foreseeable. It's typically foreseeable there are uh when there are damages, right? Like if you caused an injury and then that person gets injured later down the line, it's likely that it was foreseeable that you causing the injury could lead to the situation. Like there's one about, people don't mark a ditch and it's in a high crime neighborhood, and then a truck falls in the ditch, and then the truck driver walks back into town to get help, and then someone robs the truck. Can they be held liable for the thievery of the supplies? And the answer was yes, because it's foreseeable. The ditch in the high crime area could lead to it. Like it's kind of hard to argue against that. And then, yeah, Morgan's saying I skipped breach. I mean, breach is just the deviation from the standard of care. It's just not doing what you were supposed to do. So, like, if you were, supposed to get surgery done and the surgery came out wrong, right? That's probably going to be a breach of your duty. So, breach just means the deviation from the standard of care. And then damages would be like, compensatory to make the non-breaching party whole again, and then rarely punitive damages if it's wanton or gross negligence, recklessness that deserves punishment, right? So, look for these things to occur: duty, breach, causation, damages. We talked about negligence per se as like statutory negligence, like the defendant violated a statute or ordinance aimed at public safety, right? It could be a criminal statute or criminal ordinance. It doesn't have to be a civil statute. It just has to be a public ordinance or statute that determines a duty of care. The plaintiff is a member of the class the statute or ordinance is meant to protect. The plaintiff suffered an injury that the statute or ordinance aimed to prevent, and the plaintiff's injury is caused by defendant's violation of the statute or ordinance. So it has to be, it does have to be causation, and then there has to also be like that alignment of this is why the statute was created, right? If it's like, there needs to be a sprinkler in the house, in the building, and then there's a fire and someone, gets burned by the fire. Well, that's exactly the type of injury that it was designed to protect, right? So you got to kind of look at it and be like, a car accident is the exact injury that was designed to protect when we're talking about a speeding speed limit, right? So defamation, so defamatory statement that adversely affects the plaintiff's reputation, it must be based on specific facts, like name calling is insufficient. Also, they have to hear it, right? There's a question where it's like, I don't want to give them stereotypical names. Let's just say A and B are two Russian people and they're speaking in Russian and they're talking shit, defaming C. But C doesn't speak any Russian and no one else speaks Russian around them. That's not defamation because it has to be reasonable that someone else could hear it. There's one question where they're like, oh, they're talking, I say talking shit, but they're defaming someone and there's a thin partition. Well, it's like, why'd they use that word thin partition? Because, it can be heard through the partition, right? They tend to use language that like alerts you to like, make conclusions, right? So it's a defamatory statement that adversely affects reputation, reasonably understood that the statement concerns a living plaintiff, a very small group of plaintiffs are identifiable. The statement must be intentionally or negligently made to a third person, and harmful to the reputation. This is what's tested a lot, is that if it's a public figure or matter of public concern, you need to show malice in the sense that there's knowledge of the falsity. Otherwise, if they're private, they just need to show negligence. One thing that they test about defamation is when it's invited, right? Like if I get this all the time. People, applying to the bar exam or applying to law school or whatever, they use me as a reference, right? So I get this letter in the mail and they're like, what do you think about Tommy? And let's say Tommy worked for me and I thought he sucked. I'm like, Tommy was terrible. I think he was stealing cookies at the cookie jar, right? Like, if I thought that was true and Tommy sent the reference letter out to me, like, it's kind of privileged in that sense that they invited the libel, let's say. Now, if I'm just doing it and I knew it was false and I still say it, then that probably would still be defamation. But like if I, reasonably thought it was true and they invited it to me to say it, then I would have a defense. We talked about slander and libel per se, right? Crimes of moral turpitude, loathsome disease, unchastity about a business. So that means that damages don't need to be proven. They're presumed, right? And then truth is a complete defense of defamation. And these two statements I kind of got from my essay class, so you don't need to worry about them. Okay, and then products liability. So products liability, like I said, someone puts a defective product in the stream of commerce and causes injury. So typically it's going to be strict liability, right? You can also have a negligence theory. You got to look at the call of the question. If it says, can Tommy prevail for negligence or can Tommy prevail for strict liability? Those are two different questions that potentially have different answers. So, a lot of this comes down to reading comprehension and careful reading. Make sure you're answering the exact question being asked and you know what claim of action you're identifying and analyzing. So products liability can be intent, negligence, strict liability, implied warranties, and express warranties. The prima facie case for a products liability claim based on strict liability includes a commercial supplier of a product producing or selling a defective product, actual and proximate causation, and damages. The plaintiff must prove that the defect existed when the product left the defendant's control. For liability to attach, the product must also reach the plaintiff without substantial alteration. Generally, privity between the parties is irrelevant except for certain warranty theories of liability. So strict liability, you're thinking about, design defect. It failed the risk utility balancing test. That's a key buzzword for the MBE for a design defect. It failed the risk utility balancing test. A manufacturing defect means that it was designed properly, but they made it wrong. It came off the line differently than it was designed. The inadequate warning or failure to warn, look for the inconspicuous versus conspicuous. Inconspicuous means you can't really see it. Conspicuous means like that shit is right blasted out on the front. So if it's a conspicuous warning, that's a good warning. If it's an inconspicuous warning, that's pretty hidden and that could give rise to inadequate warning. There's one concept that I don't know if it's tested often, but the more you know, right, the better. This is the market share liability theory, meaning let's say it's defective pills, right? Like flu medicine or something. I don't know. It's these pills that are made, and Moderna and Johnson and Johnson and Tommy, right? Johnson Johnson makes 50%. The other two, Moderna and Pfizer, that's what I was thinking of. Moderna and Pfizer make 25%, right? And then it causes injury. But you don't know who made the pill that caused injury. Well, in that case, under the market share liability theory, you could say that Johnson Johnson is liable for 50% of the injury and Moderna and Pfizer are liable for 25% of the injury based on that market share liability theory. If you've never seen that question before, it's okay if that went over your head, but that's just something that I've definitely seen on the UBE at least. And it's, something that anything could be tested. Also, the component manufacturer, like if you, assemble or produce something that's non-defective and then you send it off to an assembly shop and they assemble it wrong, well, you're not going to be liable because your component was not defective. For there to be a strict liability, products liability case, it has to be defective when it left the person's control. And then anyone downstream can be held liable. So with these cram guides, with these PowerPoints, I have cram guide, right? Like yelling and shaking a stick and then striking a horse that someone is sitting on constitutes assault and battery. Remember, the horse that someone's sitting on is battery. Battery is a dignity tort that does not require bodily harm or emotional distress. Under the doctrine of private necessity, a boater who reasonably knows he will lose his boat in a storm can tie his boat up in a private dock until the reasonable fear passes. Similarly, a pilot doing an emergency landing can claim the privilege of necessity. See, these are all things I talked about, and it really just comes with what Alex was saying. Just practice questions, practice questions, practice questions, reinforcing the fact patterns, right? We love the saying, same clown, different wig, where, you'll encounter these questions on the test if you just come really familiar with them. And then installer having the logo and driving the truck of the manufacturer gives rise to apparent authority. So the manufacturer could be held liable for installation defects, right? If they have the logo, there's apparent authority. That would be the respondent superior, things like that. So these cram guide points that I have are all on the cram guide that's in the classroom. So, y'all are welcome to go through them, read them, master them. We've been creating our own cram guide as a class, right? I put it up here, the Feb 26 MBE Master Cram Guide, right? We already started. We did 25 questions. You guys helped me get 25 of them correct. That's always a good way to start things. It was pretty cool, right? And so we have this cram guide that we've created that, it's just it's good practice, right? You should be doing that on your own. When you do practice questions, you should be creating a cram guide yourself. And then here it says cram guide, Torts cram guide, like, right? You can see I took those points from the PowerPoint right off of this cram guide itself. And it's a lot of good points on here that, you should just read over, memorize, master, and create them on your own, and just like turn this into your mode of study, right? Additional materials, shit. If you really want to master the test and go to the ultimate highest level, this right here is the restatement of torts, right? This is where it all comes from. Like all the, if there's a cause of action that you're not really clear with, I recommend going right to the restatement itself and kind of reading what's the black letter law on it. It really is a good way to study if you're ready for it, if you want more and you're confused or whatever. I recommend the Federal Rules of Civil Procedure to do that with too, right? Like just, the more source material, the better. And then we have, some outlines and things like that you can study from, colorful things, exam tips. Like, I think this one was made by Danny, and y'all get to meet Danny soon enough. This is all really good stuff. And obviously the questionnaire we'll go over in detail in our next class. These are just like points of law that, you should turn into flashcards, turn into memorization, right? Like if you can go through all of these different ones, it would be really, really great. And you would really be at a high point of passing this test, right? There's a lot of stuff on here that it's just good to know. And, there's a lot of ways to learn it, right? NID, the zone of danger, and the bystander, closely related, present, personally observed it, right? Good stuff, right? This is like a really good thing to do. You can fill it out on your own, or you could look at the one that's already filled out. All right, I'm gonna take a look at Julian's presentation. I remember he did it last time. I just I don't know. I love my team and all my presenters, but I feel like I've been doing this the longest and I can make sure I leave no stone unturned. So I'm not having as many guest lectures this administration as I have in the past, although I will be for my Florida course tomorrow and on Saturday for at least half of the time, because I'm going to be teaching for the UBE. So if you're in the UBE course, you'll get some of me this week. But anyway, my guest lectures are amazing. Julian, super baller. He actually gave me heat tickets when he was studying for the test. He took the test, and then before his results came out, he gave me 2 tickets to the Heat game. And I was like, bro, you're guaranteed to pass now. And sure enough, he passed with a lot of room to spare. So if you're in doubt and you're waiting for your results and you're feeling anxious, there is 100% passage rate for giving me Heat tickets, preferably lower level center court. All right, so battery and assault, we talked about. Battery is punching the person. Assault is like throwing the punch. Transferred intent, right? We talked about it could be person to person, or it could be tort to tort, like you intended to do assault, but you actually landed the battery. Well, you'll have the requisite intent. You can tell he likes basketball. Transferred intent. So a notable NCB question involves Malfoy trying to punch Harry's owl, but accidentally hitting Harry instead. This is not transferred intent because it's transferred intent applies only between humans, not animals. Since Malfoy intended to hit an animal, Harry would not have a valid claim for barrier assault. There you go. His example was Harry Potter. My example was shooting a deer. right? Different, same clown, different wig. You can't have transferred intent from animal to human. I gotta be honest, I'm not the biggest Harry Potter. I got some things, but I never really got into Harry. Defenses to battery and assault. I don't really know what this guy is. Defenses to battery and assault. Oh, defense. Like we said, self-defense is a good one, right? You can stand in the shoes of others, or if it was somehow privileged or consent, right? We implicitly consent to ordinary daily contact, such as a tap on the shoulder, right? If you just tap someone and say, hey, your bus is coming, that's not going to be battery because that's a normal touching of everyday life. In sports, consent covers normal game interactions, being tackled in football, but it doesn't extend to intentionally harmful actions, hitting someone with a helmet. Consider examples in golf or tennis. What contact might be consented to, right? Like, what's this guy's name? McElroy or something? The tennis player who used to like, I'm talking about Johnny McElroy or something. The tennis player who always freak out and throw his racket. This might be before your day, but there was this one tennis player who was famous for
His name's McEnroe.
McEnroe. Yeah, McEnroe. He was a wild guy, and he used to throw his racket. If he threw his racket after the game and that hit someone in the head, that's definitely battery. Like you didn't consent to that, right? If he hits the tennis ball on a serve and it hits you in the head, like you probably consented to that, right? There's one question about like a jockey on a horse and he like cuts someone off, and then by cutting him off, they run into the fence, and that is considered battery. I mean, that question is kind of an MBE question because in the real world, I don't think it necessarily would be battery, but they say like as long as you intended to do the action that caused harm, then that would be that could be battery. Yeah, John McEnroe. Yeah, that's a while ago. False imprisonment. You can see Stewie and Brian. They're falsely imprisoned. They don't look very happy in there. Right? They know they're harmed by it. It's definitely false imprisonment. So consent is a defense to false imprisonment, willingly participating in an escape room. The confined person must be aware of the confinement. Someone locked in but unaware, asleep, released before waking, has no claim. Imminent threats, don't leave or I'll harm you, constitute false imprisonment. Imprisonment may be lawful if reasonable for self-defense, like Kevin locking burglars in home alone. That's a good one, right? Let's say you're being a hero, right? Like crazy drunk lady at the bar has got a knife and she's slashing. Okay, you throw her in the storage locker and lock her up until the police come. That's not false imprisonment, right? You're privileged for citizen's arrest, let's say. This one right here, the escape room thing, I've never done the escape room. I don't know about escape rooms to me. I feel like either you escape or you don't. And if you don't, it's not that fun. And then if you do, then that's it. You escape. I don't know. I feel like it's not on my highest to-do list, but I guess I'm just curmudgeon these days. So trespass to shadows versus conversion. All right, yeah, this is conversion. That's trespass to shadows. That's a good way of thinking about it. Conversion is way more serious. Total diminution in value, where trespass to shadows is just like a dent in the car or something like that. Trespass to land. All right, here we go. I like this. Sandlot, classic film right there. Trespass to land is intentionally entering or remaining on another person's real property without permission. So here, yeah, the dog's got the baseball and they're going to trespass onto the land. Damage to land are not required for viable case of trespass to land. It's kind of like I said, a dignity tort. You just have to do the thing that is trespass and then liability can attach. IIED, so extreme and outrageous conduct that intentionally or recklessly causes a person to suffer severe emotional distress. Medical diagnosis or physical manifestation not needed for IID, but typically needed for NIED. So for NIED, you typically follow the impact rule, which means there does need to be some physical manifestation, but there are exceptions to that. One of them is like the mishandling of a corpse, right? Like if, the body was supposed to be buried, but it was accidentally cremated, we can assume damages there for NIED. So you don't always need a physical manifestation. It's not strict liability. You're not strictly liable for like the mausoleum mishandling, but it is a heightened case where damages can be presumed. So that's a thought. Example of IID could be prank calling someone every night to the point it causes the person severe emotional distress, like the Bart Simpson. And other examples, like I said, painting racial epithets on someone's house. I mean, really fucked up stuff that would amount to IIED. But it can't just be like, oh, they were annoyed by it. They have to have some like longer lasting distress. So duty to rescue fireman rule, here we go. Superman. Oh, so he's not gonna really tell us about it. Well, this means that, right, like it's your job. So if you are rescuing someone in the course of your job, right, the firefighter, and you get burned by flames, like you have no case there because that's your job. The police officer one, like if the officer's not at work, if he's just, off duty and you cause him injury, sure. But if he's like, in a high-speed chase, right, that's the risk of his job. And then we said there's no duty to rescue, but once you start rescuing, you have a duty to continue. And danger invites rescue. So if you negligently arrive in a dangerous situation and the person who rescues you is injured in the course of rescue, you can be liable for their injuries. Negligence, big piece, duty, breach, causation, damages. People often forget that there needs to be damages for negligence, right? Like if there's no damages, there's no claim of action. You need all the elements to be met. So Vicky, a babysitter, owes a duty to supervise Timmy. If Timmy wanders into the street and gets injured, Vicky's failure to supervise the breach would cause Timmy's injuries, the damages making her liable. Other examples, right? Negligent supervision, negligent hiring, negligent entrustment, negligent training, negligent design, negligence, NIED, negligence per se, res ipsa loquitur. There's a lot of different theories of negligence for sure. So you have the duty to foreseeable plaintiffs, examples of foreseeable plaintiffs, right? Like the bus driver to other people on the road, to people in his bus, things like that, right? The duty to act as a reasonably prudent person would under similarly situated circumstances. So normally reasonable person test, child doing adult-like activities is held to adult standard, otherwise held to a standard of child of similar age intelligence. A person with physical disability is held to a standard of other reasonable person with such disability, like if they're blind or if they're in a wheelchair or something, but not like IQ. You can't be like, oh, I got a low IQ. Like, how should I have known better, right? You don't get a lower standard for, a IQ like argument. And professional judged by the standard of the profession. Like I said, medical professionals, doctors typically will have that national standard of care. The landowner duty of care, so the duty to inspect of known dangers and inspect for invitees, right? That, right, you have the reasonable sweeps for the invitees. Duty to inspect of known dangers for licensees, so right to warn and make safe known dangers. Duty to known trespassers to warn or protect them from man-made death traps, right? So, yeah, you have a duty to protect. Unknown trespassers, you really don't have a duty to, except you can't intentionally harm them. You can't have like, a trap or attack dogs, right? That just attack anyone who trespasses on your property, because that's pretty ridiculous. Attractive nuisance doctrine protects children from man-made traps likely to attract a child's presence. You have a question, Morgan?
Yeah, how do we remember the difference between, like, in terms of duty between licensees and invitees?
They're pretty much the same. Just think of licensees as social guests, like someone over your house. Invitees as business guests, someone who's there to confer a commercial relation, like if they're shopping in a store. And they're pretty much the same. You owe the duty to warn, the duty to make safe. The only difference is if they're a business guest, then you have to do the reasonable sweeps. Like you have to have someone who goes and checks the aisles every 20 minutes to make sure there's no foreign transitory objects on the ground or something like that. If it's just your home, you just have a duty to make safe. Like you don't have to like every 20 minutes, go check the house and make sure that no bananas have fell or anything like that. So they're both pretty high, but the invitee is even higher as a business guest
Because of the inspection.
because of the inspection, right? That's the additional piece, right? They have the duty to inspect, yeah. Okay, the breach, examples of breach where the plaintiff acted unreasonably. I like this, acting a fool, right? Doing something negligent, deviating from the standard of care. Causation damages, the breach has to cause the damages for viable negligence to claim. If JaVale McGee, that's Shaq and JaVale, they got a little beef going on. If JaVale McGee breaches his duty, but such duty doesn't cause damages, there's no viable claim against him. For causation, ask if the injury was a foreseeable result of the breach, right? Actual proximate cause, there has to be causation, there has to be damages. We need all four, right? Duty, breach, causation, and damages. Main defense to negligence, contributory negligence. Yeah, I was driving too fast, but you didn't have your seatbelt, so it's your fault too. So pointing the finger. And we talked about pure comparative is what we assume. Contributory negligence jurisdiction means any negligence will bar recovery. And then a modified/partial comparative fault jurisdiction means that if you're over 50% at fault, you'll be barred from recovery. Assumption of risk, we'll see more in strict liability, knowingly and voluntarily taking the risk. An example, barbed wire fence question, right? That's a good question. If you climb someone's fence with barbed wire and get injured, you assume that risk because it was open and obvious that barbed wire is like pointy and blood inducing. Here it is, barbed wire. If the danger is obvious, then you assume the risk, right? Fair enough. Negligence per se, we talked about the person breaches the statute, and the breaching of such statute causes the type of harm that the statute is meant to protect and harms the class of person the statute is meant to protect. If Dale goes 50 miles over the speed limit and such speed causes a noise that hurts my ears, can I sue him for negligence per se? No, because it's not a type of harm. I wouldn't be the type of person, right? It wasn't for ear pain. It was for, speed racer crashes and things like that. That's a good example. So what would be negligence per se? Like we said, the sprinkler example, not having a sprinkler when it's statutorily necessary, the speed limit example, and causing an accident, those would be good negligence per se arguments. Or like food safety, right? The food has to have, this many preservatives or something, and it has more, right? It's breached that per se. Res ipsa loquitur, thing speaks for itself. So the defendant has exclusive control. That's a key buzzword for res ipsa of the instrumentalities, and such instance doesn't happen in the absence of negligence. Such instrumentalities cause the injury. Example: the defendant owns a warehouse that's 3 floors. I'm on the street walking past the warehouse, and equipment from the warehouse falls out of the 3rd floor window and hits me in the head. Right? Yeah, the pot on the balcony. But okay, a landlord owns a apartment complex, and he owns 90 of the units, and one of the pots falls. Can you sue the landlord? No, because he's not responsible. It would be the tenants, right? And then you got to prove which tenant. Like, it's not just saying that like someone must be responsible. It's saying like, no, we know who's responsible, and it's you, right? Like, you are under the exclusive control. Strict liability for abnormally dangerous activities for which you're liable, even if you acted with the utmost care, like blasting, right? Detonation, dynamite. These are things that are abnormally dangerous, and there's you're strictly liable. You can't say that. You don't need to prove negligence. You're just liable because you caused the injury. So wild animal or chemical explosives is normally tested, right? But chemical explosives that fall and don't explode normally are not strict liability. So like, yeah, that question is a good example. There's a truck that has chemicals in it. It starts leaking. Mario Kart is driving behind and slips on the leak and hits a tree. Is that going to be strict liability? No, because they weren't injured by the toxicity of the chemicals. They were injured by some other property, right? You have to be, for strict liability, you have to be injured by the toxicity or the inherently dangerous component of the instrumentality. So a snake without teeth that scares a person into feigning a strict liability, right? Like, it's a wild animal, it's a snake. You don't have to get bit by the snake. If the snake chases you and you run into a pole, that's still a wild animal that caused the injury, right? Defense of strict liability is assumption of risk, like a waiver to ride a roller coaster, or like we said, the bomb inspector, that's part of his job, inspecting the bomb. So make sure you understand the difference between strict liability and negligence. Negligence, you have to prove they deviated from a standard of care. Strict liability, you just have to prove that it caused damages and it was, their product or their animal or their inherently dangerous activity. So NIED, I don't know, I guess this didn't load. Maybe his whole point was that like you guys have NIED for seeing what's on here. But remember, NIED is different than IIED because it's not intentional, but it causes lasting distress. And then there's the bystander claim. Either they're in the zone of danger, like you're in the car and the blood splatters on you, right? Like you're right there. Or you witness it, you're a close relationship, and it causes injury, right? Like you're present there. So those are different ways that there could be a bystander claim for NIED. It just means that you're caused emotional distress, but the person didn't cause it to you intentionally. Private nuisance. So private nuisance is substantial and unreasonable interference with the use and enjoyment of land owned by individuals, small number of individuals. The defendant must act intentionally, negligently, or recklessly. Normally, they test the reasonableness of the interference by determining if the person affected had ordinary sensibilities or not. A person who sleeps during the day can't complain about factory noise during the day. Also occasionally test that the person affected must be the landowner, not the renter. Okay, fair enough, right? Like the landlord would have to bring the nuisance claim. There's also the concept of moving into the nuisance, right? Like the answer to this one question I'm thinking of is they would take into consideration that this was a frat house partying, and then you knew that when you moved in there. It doesn't mean that you're automatically liable or not liable. It just is taken into consideration if you move into the nuisance, let's say. Puffery versus negligent misrepresentation. So puffery, this is the best car ever, which is fine, even if the car is objectively not the best car ever, right? You're just, this guy looks like a salesman. Negligent misrepresentation is the car is made of vibranium and has never crashed. I think that's Wakanda forever, right? Vibranium. When it is made of plastic and has crashed 5 times, right? That's negligent misrepresentation. Remember, they have to prove damages for misrepresentation. So if they say this and then you buy it and then you sell it the next day for the same price, you haven't actually suffered any damages. Apportionment of fault, we talked about this over and over, but it would be helpful to read this slide. Pure comparative negligence, a plaintiff's recovery is reduced proportionally based on the percentage of fault allocable to the plaintiff. Modified comparative negligence under type 1, a plaintiff may recover only if the plaintiff is less than 50% at fault. Under type 2, a plaintiff may recover only if the plaintiff is less than or equal to 50% at fault. So that is true. Some jurisdictions, it's like 51%, some it's 50%, but same thing, that if you're over 50% at fault, you cannot recover in modified or partial comparative negligence. And then contributory, a slightly negligent plaintiff can recover nothing from a negligent defendant unless the defendant had the last clear chance to avoid the accident, the defendant violated a safety statute, whereas the defendant's responsibility to avoid the harm, or the defendant was reckless or intentional in causing the harm. So this one's tested, I've seen it before, the last clear chance doctrine, which does apply, meaning that like if you had the last clear chance to avoid the accident and you didn't do it, then they can recover, right? Because you're supposed to avoid accidents if at all possible. Vicarious liability, back to Harry Potter and Ferris Bueller. Okay, it's a nice little mashup. So an employer is liable for the torts of an employee for acts committed within the scope of employment. Like Voldemort will be liable for actions of the Death Eaters as their actions are committed within the scope of employment. Employers are not liable for actions during a frolic outside the usual course of employment, right? Alex and I went on a little frolic earlier, but are liable for actions during a detour. A detour would be a delivery driver stopping for coffee. A frolic would be the delivery driver worker skipping work to go to a baseball game like Ferris Bueller and crashing in the stadium parking lot. Yeah, they got up to some mischief, right? And then defamation, slander, spoken words and gestures. Libel is written communication or published, like the radio would be actually libel because it's published, or like television is typically libel, right? Slander is things that are spoken into the air. Fault depends on the status of the plaintiff. You need malice for public figures. So damages are presumed if including but not limited to accusations of a crime, loathsome disease, behaves in a way incompatible with the person's business, or accusations of lack of affair, etc. So I said crimes of moral turpitude, loathsome disease, unchastity, and about a person's business, right? And then products liability. Oh, back to this dentist. A defendant has to be a merchant and it has to be defective at the time it left the defendant's hand. Ask, is the defendant in the chain of commerce for his product? Here's a question. A dentist was numbing. A dentist was numbing a patient's gum before pulling a tooth. Although the dentist used due care, the hypodermic needle broke off in the patient's gum, causing injury. The needle broke because of a manufacturing defect that the dentist could not have detected. Is the patient likely to recover damages in action against the dentist based on strict products liability malpractice? Like we said, no, because the dentist is a user of the hypodermic needle, not a consumer, right? Right. I'm sorry, not a producer. The dentist is a consumer, a user, consumer, not a producer, supplier, manufacturer. The dentist is actually using it as a consumer. So we talked about these types. Manufacturing defect, it departs from its intended design. It's more dangerous than expected. Design defect, it comes out exactly as it intended, but there's an alternative design that's safer, practical, and cost-effective, right? The risk-utility balancing test. Lack of warning or instructions, no warning, or there's a hidden risk. There should be a warning. If the risk is obvious, no warning necessary. The risk of falling off a ladder, right, is open and obvious. No warning is necessary. Liability, everyone in the chain of distribution could be held liable. Most common defenses to product liability, unforeseeable misuse of a product, right? A foreseeable misuse is not a defense, but an unforeseeable misuse is a defense. If you use a table as a ladder and it breaks, then the product isn't defective. You just misuse it in an unforeseeable way, right? Because you're not supposed to use a table as a ladder. I mean, Yeah, right. Like if it's a thin table and a really heavy guy stands on top of it and falls through it, like that's a not a foreseeable misuse. Um, okay, what about I'm using a lighter to burn down my neighbor's house. You know, I'm pissed at my neighbor and I go take out the lighter from my pocket and I flick the lighter, right? And the lighter explodes in my hand and causes injury. Is burning down someone's house a foreseeable use of a lighter? The answer is yes, right? So just because the use is illegal doesn't mean it would preclude them from recovery. Like you were lighting something, right? So that would be a prox liability case. Also, no need to give warning if danger is obvious. So if a set of a ladder, no need to warn if they fall because it'll be open and obvious for sure. All right, I like how that the floor is lava, and you know that's the last thing. If you missed everything, right? The obvious thing that everyone knows about torts is there's no duty to risk of the to warn of the risk of falling off a ladder because it's open and obvious. Hopefully, you get that question, you get it right. So here we um here we see that there's a lot of good things from this PowerPoint and from the other PowerPoint. And you know, hopefully you guys learned a little bit about torts today, right? Bianca, who's going to be a law student in the future, didn't even know what a tort was. So give yourself some, you know, grace that this is hard stuff, and you're not just expected to know this stuff. It's a progressive learning experience. So attend all the classes or watch the recording. So Thursday, 7 to 8:30, Sunday, 11 to 1, we'll do the workshop. Fill out the questionnaire and memorize. I showed you guys the questionnaire. You could fill it out on your own, memorize it on your own. And then review the master cram guide and the cram guide. So you review those points, review materials as needed. We're saying try to do 25 questions a day. I mean, that's a minimum. I would recommend doing all the birdie questions that we have assigned, and then, you know, trying to do even more questions from Adaptabar or UWorld or Helix or something. Like just do a hell of questions right now. So by the end of the week, you feel like you've done tons of contracts and torts questions, and then that'll set us up for winter break where we have 2 weeks off. And I'll tell y'all what I want you to do over winter break. But like it's either going to be catch up because you're behind or get ahead because where you are where you need to be. You'd much rather be in group number 2 and be spending winter break, you know, jumping ahead than you know, spending winter break trying to catch up. So yeah, that's the assignments for the week. If you're in my Florida class, I'll be seeing you tomorrow. Like I said, I might have a guest lecture for Florida while I do the UBE class, but I'll still pop in. And then regardless, there's class tomorrow from 7 to 8:30, and then for Florida UBE. And then if you're only in the MBE, I'll have class on Thursday from 7 to 8:30 where we'll really go over the questionnaire. And, you know, I'm here to answer any questions. We'll do some practice questions together, and then we'll do the workshop on Sunday. Really grateful for everyone hanging out with me this evening. I'm going to go ahead and stop this recording.